It is going live. Good afternoon, everyone. Just confirm if audio and video everything is clear. My name is Madhusudan, and today we are in the third lecture of our series of polity classes, in which we are going to cover polity from first chapter to the last chapter. All the topics of polity shall be covered in this series, and all those topics shall be covered from the mains perspective. What do we mean by mains perspective? That is, we are going to select themes on which UPSC is expected to ask questions in mains exam, and we are going to discuss in detail, in depth, what should you write if a question is asked, and we are going to focus more on why, how, so what, way forward, these kind of aspects, rather than the basic aspects that you can anywhere study in any of the books like NCERT or in Lakshmikant. So just confirm if audio, video, everything is clear, so that we could start. And this is our fourth lecture. I presume that you must have studied earlier 3 lectures. If you have not, it is available on our YouTube channel in a playlist N100. This is a series of N100 classes. In that playlist, you can watch the earlier videos as well. As you can see on the screen, this is third lecture on our fundamental rights. So in the earlier classes of fundamental rights, we have already discussed the right to equality. We have already discussed the right to freedom. Today, we are going to further extend from where we had left in the last class. So last class, we have concluded with right to personality and right against climate justice. Right to climate justice or right against climate change. After that, the two important articles which are there is Article 20 and 22. One more thing, those who are joining us live, I would request you to reply to my questions. Let's make this session engaging. You answer my question, I will answer your question. We shall learn together, we shall grow together, and in this process, we shall become an IAS officer. Okay. So just give me a second. If you have any doubt from the previous class, you may ask right now. Good afternoon, Yogesh. You seems to be the most consistent student in my class. So let's see what was there in Article 20 and 22. We have already seen it when I had started this right to freedom. There I have elaborated you about all the articles in Article 20 and under right to freedom. So please tell me, Yogesh, what's there in Article 20 and what's there in Article 22. So article, I will tell you. Article 20 is about protection in respect of conviction of offences in case it deals with conviction, and Article 22 deals with arrest and detention. Now see, this is something, arrest and detention will happen before a person is convicted in a court of law, before a trial happens, before you are subject to a court of law. Okay, and after this you will go to a court of law, and the court of law will convict you, may find you guilty that you have committed certain crime, and in case you are found guilty, then you will undergo conviction of offenses, and then there would be penalty. See, as such, these are very much factual things. The chances of these articles and the provisions we have already discussed, those provisions that there cannot be no ex post facto law and all those things, that you need to be presented before a magistrate 24 hours before, within 24 hours of your arrest. These are the things we shall cover in prelims. Here, the most important aspect that needs to be covered is that there are 3 new criminal laws that have come. Okay, India has brought 3 new criminal laws. These criminal laws, the questions on these criminal laws can be asked. And see, even if this year they have not been asked, it is very likely that next year or even next to next year, UPSC will definitely ask about them once. Obviously, if we are preparing for the next year, by that time we would also have some idea about how their implementation is going on. So then we shall also study the impact that these new criminal laws are making. Okay, so let's see. Yeah, Yogesh, you are right. One is BNS. What are the other two? So earlier we had IPC 1860, CRPC 1973, and Evidence Act 1872. Good afternoon, AEIOU. Sorry, Mr. Vowell, I forgot your name. You had told me in the previous session. Can you please reintroduce yourself? So yes, IPC 1860 has now become Bharatiya Nyaya Sanhita, BNS. Okay, CRPC has become Bharatiya Nagarik Suraksha Sanhita, BNSS. See, the beauty is in their short form. In the short form, one is BNS, one is BNSS, and Bharatiya Evidence Act has become Bharatiya Sakshya Adhiniyam. It is simple Hindi translation. Sakshya Adhiniyam. Sakshya means evidence. You know, you must have seen in the Hindi movies that गवाहों और सबूतों को मद्देनजर रखते हुए. So that means that keeping the evidence, keeping eye on all the evidence. And see, this is something many of you must have seen. This is Shaktiman and Gangadhar. And if you had followed that series, the Shaktiman and Gangadhar were the same person. This was to say like Shaktiman was Gangadhar and Gangadhar was Shaktiman. So many of the people, they are accusing that these three laws are nothing but the just change in nomenclature. So see, for what all things that can be asked with respect to these laws. The first thing that can be asked is why are we having these new laws? What was the need? The second thing that can be asked is what's new? If we have new criminal laws, what's new? The third thing is that what's good gonna happen? Why we have brought? Obviously, why we have brought will have some similarity with what good gonna happen. But obviously, there can be a question like what is the significance? What's good gonna happen? Okay, and then later on, what are the criticism of these laws? Okay, the criticism we shall study in detail, or like we are already studying in all these parts. Like when we shall be studying that, here also one criticism you can write right now. So what you can do, leave 2 pages of a space. After in the third page you already give the heading criticism. So at one place I will give you some criticism, and some criticism I will keep on telling you write at one places itself. Okay, so the first criticism comes from their name itself. That is, why are they named in Hindi? So the southern Indian states says that we have difficulty in pronouncing the name itself. Why could we not have the same name which was continuing earlier? Okay, so that's the first criticism. The government argument is simple, that we want, this is a colonial legacy. These were the names which were given by the Britishers. Why to carry on the colonial legacy? In an independent India, why can't we have a new name for the new laws? Okay, so that's the government argument, and that's the criticism. Whatever be the criticism, this is something which is going to stay because Parliament has passed it in this form itself. So whatever Parliament has passed, this is going to be there, and we have to memorize these Hindi names itself. Whether we like it or not, we have to memorize it to write in the exam. Okay. Why it is being said that Shaktiman is Gangadhar and Gangadhar is Shaktiman, we shall see in the subsequent slides. Now let's move to the next part, that why new criminal laws. You tell me, why do we need to have new criminal laws? What was wrong with the earlier laws? So one point I have already told you. See, you must have studied in newspaper, they have been covered extensively. but whether you have all the notes related to these laws at one place or not, that's important. You got to write 6-7 points at one place. And one more thing, if we go and do the research, probably we will get why, or even what's new, we will get around say 20 points or 30 points. But in the exam, you are not gonna, or you will not have the time or space to write 20 or 30 points. So we must prioritize that these are the most important 7-8 points that we will write in the exam. And that is the work that I have done for you. Okay. Yes, Yogesh, you are right. The previous one was way too old. It was too old that it was felt that this is the British legacy. This is not in sync with the modern practices. You are welcome, Satish. Let's see how much learning we are going to achieve in these classes. कुछ सेक्शन से रिलेवेंट हो गए थे. Very good point. So yes, I will say first is that they were outdated. They are so old. You can look at their ages itself. Some were made in the 19th centuries and the other was made in 20th century. So they were that old. However, just keep this in mind. That's not completely true. Like you must have known that various provisions related to crime against women were amended after Nirvaya Kand, which is also known as Delhi gang rape case. So after that Delhi gang rape case, the various provision of IPC which related to the crime against women were amended. So it is not completely true to say that IPC was never amended after say 1860. What was the year? After 1860. It has been amended after that. But definitely the core of the IPC was from that time itself. The core construct has not been changed. Okay, so it does not reflect the modern Indian society's realities and aspiration. For example, like same-sex relationship was criminalized by section 377, which was declared unconstitutional by the Supreme Court. Before moving further, I would request all of you who are online, please like the video, and if you are in the part of the group, you study with other students, do let them know, also share the link with them so that they can also join. We can have a more healthy discussion. The learning would be great if we study in a relatively larger group. Okay, so please press the like button and share it in your group. Okay, that's a humble request. Now let's move forward. Next is that obviously these laws are very complex. This is something that we all know, that our laws are very much complex in nature. Because of this, there is a lot of delays. You know, that is Sunny Deol dialogue, that tarikh pe tarikh, dates after dates you keep on getting in the in our courts. Why? Because there are so many complex laws, and even one more thing, like all the high courts are court of record. Do you know what does it mean by court of record? Court of record means any judgment given by a high court acts as a precedent, acts as law. So first of all, we have old laws which have been amended time and again. They have been added, deleted, subtracted, and then based on that, various judgments have been given by all the high courts, and this has become a complex set of laws. And because of these complexities, the advocates take advantage and the cases remain in court for years after years. Okay, like example, you can write that Nirvaya gang rape case took nearly 7 years. The case which shook the heart of the nation and conscience of the nation, which was almost open and shut case. Everyone knew what has happened. That case also took around 7 years to reach the final verdict. And then the crime is also evolving. It's not that the crime which was there in the 19th century, the same crime is happening even today. Like cyber crimes, this is the new era of crime which is happening. Like you must have got a lot many phone calls since morning, giving you free credit card or giving you free loan and all those things. Every day we get those free calls. And these calls are definitely hurting our interest, or rather definitely hurting the interest of the society. These are a new set of crimes, and we need to have new set of laws to deal with this new set of crime. Okay. See, I will share this PPT on the Telegram channel. Okay. So even if you are not able to note down all the points, uh, it's okay. But I would request you to note down the broad points and the key examples for sure. Okay. I scammed 2-3 scammers. Yogesh, you seems to be having the interesting experience. Maybe in the future lecture, sometimes we would like to listen from you if we have a two-way session kind of thing. How you scam the scammers. One more thing, once I saw one of my friend, what he did is that a scammers came. It was not my friend per se, one of my relative. A scammers gave a call and asked for the OTP and all that. He gave a what do you say, credit card number and all these things. I was standing beside that person and I was asking why you are giving credit card number. I mean, I was looking something is fishy. Okay, that person gave the number and he said, oh, he instructed me that calm down, calm down. Okay, I waited. Your money, you are doing it, whatever you do. What happens that after some time he gave intentionally just one digit wrong. Okay, and the scammer put the number and all those things, and then the scammer said that you must have got the OTP, and he said no, I did not get the OTP. And this went on for next 5 to 10 years. 5 to 10 minutes. That he said that you must have got the OTP, and with different excuses he cut the phone, he called again, and this went on, and he was just enjoying he said that I have nothing to do, I am just enjoying what he does next. But I believe that even this, you are wasting your time. He is doing his duty, his job. His job is to scam the people. Why to fall into that scam? Why can't we simply disconnect the call? Okay, let's move to the next point. Why we have new criminal laws? Because old laws, some of them were misaligned with constitutional values. See, here you got to be careful while using the language. You do not have to write like all the laws were misaligned with constitutional values. That's not true. But yes, definitely some of them were misaligned with the constitutional values. For example, sedition law. Like originally the United Kingdom government had brought sedition law in India, and they have themselves removed it from their statute, but we are still continuing with that. So this is something that should be removed, because this is also violation of our freedom of speech and expression. This is inconsistent with the principles of democracy. Okay. Then next is human right violations. This is something which is a problem with our policing system. Like the number of, can you guess? Just I want you to have a random guess that every year in police custody or judicial custody, how many people die in India? Like someone has been arrested, he is in either police. I hope you understand the difference between police custody and judicial custody. If not, please let me know, I will tell you. So every year, how many people die in the police custody or judicial custody? Just make a random guess. What do you think? Or it is different from the fake encounter. The fake encounters that are happening is different. I am just asking that every year how many people, I mean, once you are arrested, then you are in the custody of the police and there you are dying. Most likely you will die because of the torture. How many people might be dying? Yes, you are right. So in year, we have latest data with respect to 2021-22. There were 155 people who died in police custody and 2,152 people died in judicial custody. These are the number of people who were the responsibility of the police and they died in the custody. Especially these people, this is a troublesome number. In jails, few people are dying. Obviously, this could be a cause of natural death as well. There could be various diseases because they are staying there for years. But when police arrest you, they keep you for maximum of 14 days. Usually within 24 hours, you have to be produced before a magistrate. And in that period, that small period also, if someone is dying, this is definitely a worrisome number. Unlike, thank you, Satish. And then you have this example of custodial death of Jairaj and Penix. This was the case from Tamil Nadu, which became very, famous because see, these people were arrested because they had opened their shop when due to COVID virus, all this lockdown was imposed. So when lockdown was imposed, they had opened their shop, police came to their shop and asked to shut down. Because of that, this process, some altercation happened. Police arrested the father and son duo. They were father and son. They were arrested, most likely tortured, and ultimately they died in the police custody. Okay, and there are so many instances. Obviously, the police officer concerned in this case was suspended and an inquiry was ordered. Now, can you make a guess that how many police officers? See, there are 155 deaths happening. So they all, as per the Supreme Court orders, every police custody death has to be investigated by a magistrate. So how many of them must be getting convicted every year? Just make a random guess. How many of the police officers or police constable, police personnel, must be getting convicted every year? On an average, 155 deaths are happening in their custody, in their lockup. How many of them are getting convicted every year? Okay. AEIOU is saying 10 to 20. Yogesh is a bit more optimistic, 20 to 30. Yogesh, you would be surprised to know that in last 20 years, there have been only 26 convictions. In last 20 years, what you are expecting every year, it is happening every 20 years. So on an average, you can see that barely one police personnel is getting convicted every year, even though 155 people are dying in police custody. So see, you can see what is the lack of punity that police officers are feeling with respect to the people. That even if you die in my custody, nothing is gonna happen to me. Less than 1% chance is there. And this is something that you can write even if a question comes on police reform. There also you can quote this data that these many deaths are happening and the conviction is very low, and that's why the police brutality is continuing. I'm not saying that the criminals are not doing wrong, but police is not doing wrong. That's what I'm saying. Sorry, police is not doing it right. That's what I'm saying. Okay, these data are very important to substantiate your point. This will distinguish your answer from others' answer. Okay, let me simply brief it. What AEIOU has rightly said, this is the difference between police custody and judicial custody. Police custody, as the name suggests, you are in the custody of police, and police custody means you are in police station, police lockup, what we see in the movies. Okay, that in the police station itself, there is a lockup. In that lockup, if someone is there, it is in police custody. Obviously, why would police keep a person in its lockup? Because police wants to do interrogation. So usually at the start of the investigation, police would keep a person in its lockup because it wants to know about the facts of the question. So the purpose is police interrogation. Okay, here what we study in the constitution, that a person has to be brought before the magistrate within 24 hours. So if police has to keep anyone in its lockup beyond 24-hour period, then he must take the permission of magistrate. So usually 14 days, up to 14 days, sometimes 7 days, sometimes 2 days, 3 days, depending upon the severity of the case, up to 14 days police custody can be given in one go. Okay, now once a person is usually convicted, that person is put in jail. jail administration. Normally, jail administration is different from the police administration. The police directly reports to SP, okay, whereas jail administration directly reports to DM. It does not report to SP. So their personnel are totally different. In a state services, you say that there is a separate cadre of police services and there is a separate cadre of jail services. Okay, so jail is part of civil administration. So in case you are in jail, you are called to be in judicial custody. So if a person is in judicial custody, police cannot do investigation directly. It cannot be the police got an idea, oh, this person can tell something, so he will go to the jail and ask. No, he will have to first go to the magistrate or court, take a permission, then he can go to the jail and do an interrogation. Okay, so that's the difference between two. Obviously, here are the more chances of third degree police torture. Here there are less chances of third degree, but there could be other degree from your other inmates. Okay, that's the risk here. Here the risk from other inmates is less. And usually the criminals, I mean, obviously criminal does not prefer any kind of custody, but if you have to go to the custody, a criminal would prefer judicial custody over police custody, because in police custody the torture is given. Clear? Is there any doubt? What are the advantages of the bill? We will come to that. Significance we shall study. First we have just studied why new criminal laws. Obviously, you can simply see that we have to bring them in aligned with constitutional values. We have to remove this human right violation. So how we are doing it? These are the points also. Is that building different or is it aligned to any police station? No, different building altogether. Jail premises is completely different, secluded from a police station. There are various police stations. There are small one. Whereas if you are asking about the police lockup, they are in the police station itself. Okay, so when you are in police custody, it is in the police station itself. Whereas jail is a separate building altogether, managed by separate personnel. There is a separate jail staff who manages the jail, and when you are in judicial custody, you remain there. Okay. Now let's move further. What are the new things that have been brought under these acts? So see, there are possibility of two things. One is we have brought some new crime. Another is we give the different section or different name to the existing crime or do some modification. Okay, or we do the rearrangement. These are the three different type of things that can be done. So let's first look at Bharatiya Nyaya Sanhita. Again, I will share this PPT or share these slides on my Telegram channel. You just listen and understand the facts, and whatever quick note you can take, just take a quick note. Okay, in case I do not reply to any of your comment and you have a valid question, you can post your comment again, because in the process of teaching, I may skip one or two of your comments. So do not get disheartened, post it again. There is nothing to lose. Okay, first thing is we have introduced some new crime. For example, sexual intercourse through deceitful means or false promises to marry. This is something which is very much important for the youth. A lot many youths knowingly or unknowingly commit this crime. Okay, like when you are making a false promise to marry and you get engaged in sexual intercourse, now it's a crime with 10 years in prison. Earlier it was just considered cheating. Now it is being given a specific crime. Okay. Next is mob lynching has now been covered as a dedicated crime. Okay, whether on the ground of race, caste or community. So now it has been recognized as a separate crime. So it gives that these are the crimes on which the government is giving more emphasis. These crimes should not be committed. It's not that other crimes should not be committed, but they were earlier not being given a specific mention in IPC. Okay. Next is organized crime and terrorism has been included in BNS itself. Earlier we had a separate act, UAPA or Narcotic Prevention Act. So these were the various other acts, a specific act which were dealing with these organized crime and terrorism. Now the BNS itself has made provision related to organized crime and terrorism. So now we have simplified that all different crimes have been put together in one place itself, that is BNS. So simply simplified the workload of the police officer. He does not have to look at the different other statute. One statute, every kind of crime is there. Okay. Next is we have defined the organized crime, which also deals with extortion, kidnapping, cyber crime, and severe consequences of human trafficking. Then sedition have been removed. This is something that we looked at. Why is there a need? Because we had some crimes which were not in sync with the constitutional values. So this sedition has been removed and replaced with offenses that endanger the sovereignty, unity, and integrity of the country. Okay, so this is another change that we have done. Then we have introduced community service as an alternative form of punishment. Does anyone of you watch Suits? It's a web series which deals with like advocates based on the lawyers in USA. So in USA, we already had this community service as one of the crime, one of the penalty. In India, only two type of penalty. One is incarceration, imprisonment. The second is monetary fine. Okay, these are the two type of crime. But like in USA, we also have something called community service. This is something that we have adopted in new BNS. That someone can be asked to do the community service, that you have to serve the poor, you have to feed these many poor, you have to clean the drainage, or any such kind of things which are in nature of community service that can be given. For example, recently a case had come that in Pune, a businessman's son has killed two people on the road using his luxury vehicle. I don't remember the brand of the car. And the court has asked him to do community service, write an essay on road safety. Okay, so such things have now been given the statutory status that community service can be given. Okay, next is rearrangement of provisions. The various provisions have been rearranged in the new statute. What has been the rearrangement? So earlier, since Britishers had made the law, what they have done, that the crime against the government or crime against the state, they were given priority. They were the first listed first, and it were followed by other things like crime against women. Now this act, the government is saying that this new act is citizen centric. Since it is citizen centric, so the crime against citizens, like crime against women section, have been given priority. They are mentioned before the crime against a state. Okay. Now this is something that I was calling as Shaktiman is Gangadhar. So the crime is same, punishment is same, penalty is same, but just we have done the reject. Just we have done the rearrangement. So there is a quotation for this, usually said that old wine in new bottle. See, whenever you are writing such things, you must always write that people are criticizing or critics are saying that it is nothing but old wine in new bottle. Why? Because it has simply rearranged the most of the provisions. The most of the provisions, crimes, their punishment, penalty, etc. are same. Okay, so on this basis, you will say that it is old wine in new bottle. Never ever write that you are saying it. The language should never be that this is old wine in new bottle. If you are writing like this, that this is your opinion, whether you have this opinion or not, it gives a wrong impression. It gives an impression that you are anti-establishment. We do not have to give such an impression to the examiner. Is it clear? So with the same set of knowledge, same set of answers, you can get slightly different marks because of your language. So language is also very important in mains exam. Okay. Now let's go to the next part, Bharatiya Nagariks. See, there were other provisions also, but we have to simply write down and memorize the 6-7 provisions that are going to be sufficient for us. Okay, next is BNSS. BNSS is simply the adaptation of CRPC. Now, first thing that has happened, the police custody that we were just saying that it is of 14 days. You have just written someone. Now the government has decided to extend it to 90 days. Obviously, in general, it is just still 14 days. For certain offenses, it has been extended. Okay, like the new offenses, narcotics, terror, these are the offenses that we have adopted. And for those serious offenses, this has been increased to 90 days. Do not have to mention that only those, because see, this extension happened for certain offenses. So there are a wide range of offenses apart from the organized crime and terrorism. For them, it is definitely there, or there are some other offenses also for which it has been extended. We need not memorize all those crimes. We just have to keep in mind that this is not a blanket extension, that for all the crime, this has been up to 90 days. Okay. Next is that it allows trials in absentia. So a lot many people, what they do, they commit crime in India and then they go to England, settle over there, watch matches from there, or they go to Nepal, then from Nepal to some other country. So for them, the government has said that even if after a stipulated time frame, if the person does not present himself, the trial can go on in absence of the person. Why is trial and absentia a problem? So this is a problem. This is not, considered right. But why? What's problem in this? Can anyone answer? Justifiable. Because it is violation of principle of natural justice. The principle of natural justice says that no judgment should be passed without hearing the person. And if trial is happening in the absence of that person, he is not getting the opportunity to protect himself or herself. That's the problem with trials in absence. But if the person is intentionally running away, because if you see, if you open the local newspaper, every day you will see one or two advertisement where the government declares that that person is not presenting himself to the court. So first the letter is sent to his home, then the police goes looking after him, then this kind of advertisement is posted. Even after that, if the person is not subjecting himself or herself to the court, then definitely trial should go on in absentia, because he is running away from the law. Next is removal of a statutory bail. So there were certain conditions that if like the case is not starting, the charge sheet is not filed, the trial is not starting for such a long period, statutorily a person was entitled to bail. Okay, you must have seen it in the news recent time in case of like app candidate. So they simply argued on the basis of this statutory bail condition that since the trial has not started against them, they are entitled to bail. Now the new act have altogether removed these cases for most of the charges. Again, this has also not been universally removed. Okay. क्या ये आर्टिकल 14 का वायलेशन हो सकता है? डेफिनेटली हो सकता है. ठीक है. If we go by the principle of article 14, principle of natural justice must be followed, rule of law, slightly related, but yes, there can be a scope of arbitrariness, but obviously none of our rights are absolute right. They are subject to reasonable restrictions. So in some cases only it is saying that it is allowed if accused is not present. If accused is not presenting himself, okay, then only trial in absentia is allowed. So most likely I don't see that it can be declared unconstitutional. Okay. Next is speedy justice. It has now given a tighter timelines for the completion of trials. I would ask you people note of these timelines. So this is something which is important. This is something that examiner would expect from you. So what is the different timeline that has been given? Okay, please take a note. So first thing is, for preliminary inquiry, 14 days time limit has been given. Okay. For investigation, 6 months time limit has been given. ED would never be able to complete it. If you have seen the news recently, ED investigation is never completed in 6 months. But this is the timeline that has been given. After investigation, charges would be filed. So for filing of charges, 60 days time has been given after first hearing. So once police complete its investigation, police submits its charge sheet in the court. Now court does the preliminary inquiry, goes through the charge sheet of the police and frame the charges. So to frame the charges, 60 days time limit has been given to the court. And then after that, what happens? The trial happens, both the sides present their argument, and after presenting the argument, the first court concludes the trial. After concluding the trial, the court gives its judgment. So it's not necessary. I mean, in the films, etc., you see that, okay, now you two give your concluding argument, and after that, the court declares someone guilty. Practically, it does not happen like that. Practically, when both sides concludes their argument, then judge sits in his chamber, applies his mind, do consultation with his team, they prepare the summary report, etc., and then decides who is guilty, who is not guilty. Okay, for this purpose, 30 days to 45 days time has been given. Okay, this is time limit for judgment delivery. All the reasoning, etc., has to be typed in the judgment, etc. Okay. In total, the act says that maximum 3 years. In maximum of 3 years, the justice must be delivered. Total time taken from the filing of FIR to the delivery of judgment should not be more than 3 years. Well, obviously, it is very good, very ambitious. We would love to see such a situation in our country. Okay, but merely enacting a law is not going to change things on the ground. So maybe after 1 or 2 years, if a question is asked, this is the part which is objective in nature, on which it would definitely be tested whether any significant change has occurred on ground or not. Is it clear? So if you are appearing it next year or next to next year, unfortunately, if you have to write the exam, do keep in mind to collect data about the effectiveness of these laws. Okay. Bilkul, that's the agenda. You are right. That's the agenda, to reduce the numbers of under trial. So in significance part, we shall see it, that what is the significance of these changes. Let's see first here what changes have been brought to Swarthi Sakshya Adhiniyam. This has brought only one effective or major change, and that is the recognition of electronic records as primary evidence. It is saying that electronic records should be the primary evidence. What do you mean by primary evidence? The evidence which in the Indian Evidence Act, certain evidence have been declared as the primary evidence. Certain evidence which indirectly establishes the guilt, etc., they are considered the non-primary, secondary evidence. Okay, so till now those things which are digital in nature, they were considered as secondary evidence. Now this has been changed. Okay. And like even secondary evidence have been there, certain new things have been added in secondary evidence also, like oral and written admissions and expert testimonies on document examination. So now they are also being included as the evidence. And then electronic and digital records can be included in the digital form itself. It's not that if like an email is being introduced as an evidence, they would be accepted in the digital format itself. It's not that a printout would be taken, someone will sign an affidavit on that, attest it, and then after attestation it would be admitted. Now those records can be included in the digital format itself. What's the benefit of all these things? The benefit is that it would expedite the process. If you have to submit the same evidence by changing the form, bringing about certain changes, it would take time. So if you want to deliver a speedy justice, you have to accept the digital records, and digital records are a reality. There is no running away from it. So modern justice delivery system must bring about these changes. जेल में मोर देन अंडर ट्रायल्स वाले भरे पड़े हैं, कुछ लोग तो ऐसे हैं जिनका एक्चुअल पनिशमेंट ज़्यादा अंडर ट्रायल काट चुके हैं. Yes, definitely we very often see, and there is this data that 75% of imprisoners, 75% of prisoners are under trial in India. So those people who are in jail, 3/4 of them have actually not been found guilty in any of the offenses, and they are in the jail. So this is definitely a problem. Okay. Next point is, what is the significance of new criminal laws? The significance is that now our justice system is going to be reformative justice system. Why? Example, you can say that community service instead of imprisonment. Okay, so the punitive system focuses on punishing the offenders for their wrongdoing, while reformative system aims that they can be rehabilitated. The agenda should be to bring them back to the society, bring them as a non-war individual being. Someone who is a criminal, committed a crime, has has the scope of becoming a civilized citizen. This is the presumption in reformative justice system. Obviously, modernization, evidence act example, you will see. See, the question is not likely to be that what changes have come, like all the aspect that we are studying may not be asked in a question. So if question is only asking about significance, you will write them and give example as well. Like in modernization, you can give example from evidence act. Embracing technology, you can say that video conferencing trial has been now given part of BNSS. Okay, there is also a one thing like forensic investigation have been made mandatory. So in any crime, if the punishment or the charges that have been framed can lead to more than 7 years of imprisonment, for them there is mandatory forensic investigation. Okay, a speedy justice, you can talk about all the time limits that have been there, that maximum 3 years the justice must be delivered. Decentralization of power, here also an important provision have been done that the victims are entitled to receive police documents. What happens that when police is committing an investigation, doing an investigation, We often go to the police station, ask for the document, and what have you done, who is being considered guilty, what is the charge sheet that you have framed, and sometimes police deny it. So now it has been made a statutory that those who are victims or their family, they are entitled to all those documents. Police must inform them how they are investigating, what are their progress. Okay, so decentralization of power. Now people, victims are being made powerful. Okay, and then some anomalies have also been corrected, like sexual intercourse with a minor wife has been brought under the ambit of rape. Earlier it was like that if it's your wife and minimum age is 15 years, sorry 16 years, then it was not a rape. Whereas it was in violation of POXO Act, Prevention of Children from Sexual Offences Act. POXO Act saying that any sexual intercourse with any child who is less than 18 years of age is a crime. Whereas the IPC was saying that if it's your she is your wife, then it's not a crime. So this anomaly has been corrected. Even if she is your wife, sexual intercourse is a crime. You got to wait till she turns 18. Okay. So these are the points. These are the examples. Examples are must. Not only you have to write what has been the significant change, you have to give example for all these changes. Okay. Any doubt? And one more point that we have just discussed, that it will reduce the number of under trial. So a speedy justice will happen. After this point you can write a speedy justice will happen, and it will also reduce the number of under trials in our jails. Next point that we shall study is what are the concerns. So a lot many concerns we have just already studied. Like we have studied the concerns with respect to the nomenclature, the name that have been given, the concern with respect to the increased period of custody. If the period of custody is high, there are high chances of police torture. Okay. सर स्पीडी जस्टिस के लिए नंबर ऑफ जजेस एंड कोर्ट्स भी इंक्रीज करनी होगी डेफिनेटली, बट दीज आर द एक्सिक्यूटिव थिंग्स. एक्सिक्यूटिव कैन इंक्रीज these acts. You can write this point as well, that to just write, if you just mention it in the law that you have to complete the process within 3 months or within 3 years, sorry, it is not going to be implemented on the ground. It's not that the judges will stop going on their summer vacation and they will do on writing the judgment just because the law says that. Practically it will not happen, right? So you can say that you need to increase the infrastructure, you need to increase the judicial officers. Okay. And also it makes a provision that every crime where the expected punishment is more than 7 years has to be investigated by a forensic team. Where are so many forensic experts? Do we have forensic laboratories in every district? Or for that matter, even not only every district is not going to be sufficient, maybe in every police station or in every circle at least, you got to have a forensic expert. If that is not there, how are we going to implement it? What are the concerns? Now, apart from those concerns that I have just told you, you must write down those points also. We have to write some other points as well. Now, first thing is that how we have decided that these are the offenses under which no jail term like community service is going to be provided. No jail term means community service. So, no rational basis or logic seems to be given. This is one criticism. Next is, what is a community service? This has also not been defined. So ultimately, this has been left to the discretion of the judges. So few judges might feel that writing an essay is a community service. Few can feel that you will have to feed the poor. Few can feel otherwise. They can have their difference. Few will feel that you must go to the temple and recite the name of your God. So why to leave to the discretion of the judges? Why could not we have defined the community service itself? Okay. And in case of sedition, the penalty, the criteria, all those things are still the same. Only name has been changed from Rajdrah to Deshdrah. It is not going to make any practical difference. And then you have removed the provisions related to section 377 and it has not been brought or replaced by any other provision to protect the sexual assault victims which are male. And do not laugh at this. This is also a reality. Such crimes are also happening, although less in number, but some sexual assault victims are also male. Okay, so how to protect them? Then police custody, this is a problem. Now another problem is that the definition of terrorism etc. we have adopted from UAPA and we have brought it in the BNS itself. This is again also, this is open to misuse because those acts have very stringent provision. The UAP or Terrorism Narco-Terrorism Act, they have very stringent provision, and because of that also there are stringent safeguard. They have safeguard like you must get permission from an officer of the rank of SP to arrest certain person. But you have not brought those safeguards, simply you have adopted the definition from those acts to BNS. So it is open to misuse. Okay, and then the last point is that they have been passed in haste, because of which what happened, there was an Indian Express report the day on which these were implemented. The Indian Express has done two things. They went to one police station in Madhya Pradesh and they went to this Parliament police station in New Delhi, and they found that the Parliament police station in New Delhi is completely in readiness. All the constables, the police officers, they are well trained with these new acts. They are in readiness. Whereas in Madhya Pradesh, the police station in charge, the police station that they visited, he had not even got the copy of the new acts that were coming in force the next day. He said that one session has been conducted, but not everyone was able to attend those sessions because of various busy schedule, etc. And so not a rigorous training has taken place. Not proper understanding has not developed throughout the corners of India. You can cite the Indian Express report in your answer. And obviously when the bills were passed at that point of time also, wider consultation etc. was not done. Okay, so these are the concerns. Obviously with respect to these concerns you can write about the way forward as well. Okay, is there any doubt, any aspect of these laws that you would like to discuss? There is one doubt. बहुत केस में तो पुलिस इन्वेस्टिगेट करते टाइम एविडेंस को कंटेमिनेट कर देते हैं जिससे केस लंबा चलता है, फॉरेंसिक वाले से फायदा होगा. डेफिनेटली द प्रोविजंस आर वेल इंटेंडेड. इफ दे आर इम्प्लीमेंटेड इन spirit, letter and spirit, they will go a long way in improving our judicial system. Okay, in fact, if any questions comes on say delayed justice in our country, you must write that if we implement the provisions of these laws, this would be very helpful. If the question comes about the huge number of under trials, then also you should write it. The problem is there has not been any provision related to infrastructure, related to police reforms. Like in police reform, there is one point that you have to separate the investigation wing from the administration wing, the law and order. There has to be a separate police cadre for investigation and maintaining law and order. That has not been done. Yes, obviously training is a state matter. Achha, one more thing, like policing is a state matter. So how come these laws have been uh, enacted by parliament? Police, law and order, these are the things which are in a state list. So how come parliament enacted these laws? Any idea? Any guess? Because criminal laws are in concurrent list. Policing and law and order is in a state list, but criminal laws is in concurrent list. Both parliament and state government can have a legislation on criminal law. Okay. Next, we are going to see the rights of freedom of religion. Okay, right to freedom is complete here. We shall see right to freedom of religion. Here also, see, as we have done with other rights, we are going to pick a few themes on which question can be asked. The basic aspect, what is there in our constitution, I expect you to know. Okay, in future classes also, those who are like attending these sessions regularly, I would say that you do some homework, a study on your own, some of the prelims related facts, etc. Then come to the class for the advanced studies, for the theme based studies. In this way, your preparation of polity would be holistically complete. Okay, and you will have the confidence to write any question that may ask. See, when a question will be asked, it will definitely cover things which you might not have covered in the class notes or in any class. But the confidence that you will get will help you in writing answers. It would never happen that you do not have content. If you apply your mind with confidence, you would definitely be able to write answers. Okay. Tell me first the article number, from where to where we have right to freedom of religion. Yes, please. 25 to 28. The first thing is, let's understand Article 25. What does Article 25 says? So Article 25 says that there is freedom of conscience, profess, practice, propagate the religion. What is the difference between these terms? These terms, conscience means what you think about religion. Which religion do you subscribe to in your mental being? Like you may believe that I belong to religion A, B, C or D, or I subscribe to this god or goddess or this Baba, etc. Whatever. In your mind, whatever you have the freedom to think. Okay, but not only in your mind, you have the right to profess also the same. You have the right to say that I am a Hindu or Muslims, or I am an atheist, or I subscribe to this panth, sect, etc. Okay, you can publicly declare it that you belong to particular religion, and you have the right to practice the various aspect of that religion. It is not, it is insignificant that I have the freedom to declare that I belong to X community, but the practices of that community I'm not allowed to practice. So if it involves going to pilgrimage, wherever your pilgrimage is, if it involves doing some sermon, arti, puja, you have all the right to do that. And then you have right to propagate also. The propagate means you have the right to tell others about the basic elements, basic teachings of your religion. You have the right to bring other people in your religion, bring other people with you. Okay. Now this is, see, many of you might have given this argument or might have listened to this argument that religion is a personal aspect. You should do it in your home. Why to sit in the public and do certain religious practices? Now, the nature in which our constitution article is worded, it makes it clear that religion is not a personal aspect. Religion is a public aspect. How? You have the right to practice, profess, and propagate the religion. And all the religions, whichever religion you may subscribe, they have various elements, various such rituals which you have to do in society, together with the other members of the society. So this argument is not valid that religious practices should be done within the four walls of the home. Religion is essentially a group activity. Okay, and it is true for all the religions. All the religions involve some amount of pilgrimage, some such activities which is done in the group, as a society, as a together. In fact, the very purpose of religion, when religion was made, or when religion evolved, the very purpose was it to bring people together. In fact, if you read anthropology, I'm just deviating a little bit from the topic, but I will just take 1 minute of yours. In anthropology, we study the evolution of religion, and there is a book of Yuval Noah Harari, and in that book he writes that how come Homo sapiens become so dominant? How did they survive? Before Homo sapiens, there were another species, Homo neanderthal. You must have come across this name, even though you have not studied anthropology. Homo neanderthal. And Neanderthal were having a brain size larger than Homo sapiens. Our brain size is roughly around 1300 cc. Theirs were 1400 plus cc. Okay, so they were having the larger brain. We believe that we have a large brain, that's why we survived and we are commanding the planet. So by this logic, Neanderthals should have commanded the planet rather than Homo sapiens. And they had come before us as well on this planet. Still Homo sapiens become dominant, or rather they eliminated Neanderthal because Homo sapiens invented religion. In the name of religion, we all came together, and when we acted together, we were able to defeat Homo neanderthal. They were also like humans, they were also a standing creature, but we were able to remove them from the planet because we started, or we invented something called religion. And the good thing about religion is that you believe in something abstract, and in the name of abstract, a lot many people can work together for one particular goal. And he gives a very beautiful example. He says, let's see, you cannot convince a monkey to give away his banana so that he will get hundreds of banana in his next birth or after death. Can you convince a monkey to give away his banana? If he gives away his banana, he will get hundreds of banana after death. But you can convince humans to do the same. That's the beauty of religion. Okay, very beautiful book. Even if you do not have anthropology as your optional, you may consider reading it. The book is named as Sapiens. It will make you an argumentative person. It will give you a lot of food for thought with respect to various aspects of our life. Okay, now let's come back to this aspect of the polity. It is very much clear that religion is not a personal aspect. That argument is void. Okay, next is that our constitution itself says that you have this freedom, but as good with our constitution, no freedom or no right is absolute. So it says that these rights are subject to public order, morality and health, and to the other provisions of this part. This part means part 3. Part 3 means fundamental right. Now read this line again. Subject to the other provisions of fundamental right. It means that this article 25 is inferior to all other fundamental rights. I repeat, The Constitution itself says that Article 25 is subject to other provisions of fundamental rights. It means Article 25 is inferior to right to equality, inferior to right to freedom, inferior to all other rights, right to education, right to privacy, everything. So when people argue in the court that, like in the temple entry case, it was argued that this is our religious freedom. We do not allow women in our temple. It is part of our right to freedom. They simply do not know the way our constitution is worded. Our constitution clearly says that your religious freedom is inferior to the right to equality that is enjoyed by the woman. So the Supreme Court has no choice but to enforce the right to equality of the woman in case of temple entry or any other matter. Is it clear? In any case that goes to court, and you have seen that courts have been consistent in implementation of this aspect. Clear? Now we shall also see, before coming to the aspect that we are going to discuss, like in today's class we are going to discuss about hijab controversy. There is an essential doctrine of essentiality which the Supreme Court has propagated. Okay, so one more aspect which is there, Article 26(2) says that a state can regulate the secular activity related to religion. So religion does not have all the activities which are religious in nature. For example, like in Tirupati temple, laddu is being sold. Okay, obviously when laddu is being distributed as a prasad, it's a religious activity. But the part of it which involves selling of laddu or making of laddu, it can be regulated. For example, you may not make laddu which is harmful to the health of the people. Suppose laddu is having those elements which is considered carcinogenic, the state can restrict the temple from making laddu in that fashion. I am not saying that such a thing is happening. I am giving a hypothetical example. Do not record it and put in public platform from tomorrow. So I am clearly taking a hypothetical example. As the case has come that there is adulterated laddu, if the government comes to know that this is something which is harmful to the health of the people, this is a secular thing, and those secular activity which is related to the religion can be regulated by the government. Okay, and also government can take social welfare and reform. Can you give me some example of social reform that has been done by the government recently, which otherwise goes into the sphere of religion? Thank you, Yogesh. I would earnestly request all of you that please bring your friends also to the video. If you are liking these sessions, do bring your friends. You will definitely have a lot of learning in these sessions. Untouchability, yes, definitely. But untouchability, I mean, the state need not do it anything else because the constitution has directly abolished untouchability. I'm asking about some law, etc., that have been passed by the parliament. Like what is done by constitution is done, na? Nothing can be done. But what like constitution is allowing on the basis of which if a state has done something. Yes, triple talaq, you are right. The parliament has passed a law banning a triple talaq, or like Maharashtra has passed a law against black magic. These are the things which are something most of the states have yet not regulated, like in the name of declaring someone as Diane or evil spirit. A lot of torture or crime, I would rather say, is committed against usually poor women or women from the lower strata of society. This is also something where social reform is due, in my opinion. And like some governments, like Maharashtra, has taken some action. Most of the governments are yet to act on this. Okay, these are simply, I would rather say, these are the people who are victim, who are like having some mental trauma or some mental illness, and in the name of treating them using black magic or something like that, a lot of such women are tortured, beaten, sometimes they die also. Okay, now the next aspect, these were the factual things, the base that I have built. Next aspect is the hijab controversy that I am going to discuss in detail. Okay, now this is a very interesting thing which is happening. Even like courts recently, family with 2-year baby was killed due to black magic. Yes, I mean a lot such instances keeps on happening. We need a specific law for that. Like obviously some of it have been covered, but even like the mob lynching does not cover this uh, on the accusation of black magic aspect. Like mob lynching has been declared a offense under new BNS. Okay, but it is still mob lynching is considering on the basis of race, on the basis of caste and community, not on the basis of black magic and such things or rumor mongering. So those who have spread the rumors, they should also be booked. So we need a dedicated law for this purpose as well. Now let's come to the next topic, which is related to hijab controversy. See, we must have understood, or we must have come across various aspects of this. So my agenda in this class is going to be to understand the two sides of the argument. As of now, the law is not being settled by Supreme Court. Okay, so we shall understand that in various courts have given some judgment, like Karnataka High Court has given judgment, Bombay High Court has given the judgment, Supreme Court has also given a split verdict. So what has been the argument on both sides? And then I would also tell you my personal opinion that what you should write. Obviously, you are responsible for your answers. You are responsible, you would be accountable for that. So you can have a different perspective. I would be ready to discuss a debate about the perspective that you want to take. Any perspective that you take in the exam must be backed by proper reasoning. Any reasoned perspective is well justified because the courts are also divided as of now. Okay, let's simply understand. First, the controversy erupted in Karnataka, where the few girls students who were wearing hijab on one particular day, they were not allowed to enter in the school. They went to the first, they requested their school principal, then they requested their school board, their board, then they went to the ultimately to the court, and court said that hijab is not must in Islam. Bombay High Court's uphold ban in college, said it's a student's interest. So first it happened in Karnataka. Then Karnataka High Court gave the judgment that it is not necessary, that you have to wear hijab. Then the similar thing also happened in Bombay, and Bombay High Court has also relied upon the judgment given by Karnataka High Court and said that hijab is not must. However, the matter also went, I mean this before the Karnataka High Court judgment was challenged in Supreme Court, and Supreme Court delivered a split verdict on Karnataka hijab ban. The two-judge bench, usually there is something called division bench. So division bench has two judges. Okay, so the two judges were having different opinion. The one was saying that the state is right in banning hijab. The other judge said that the state is not right. So now the matter has been, in case both the judges do not concur on the judgment, they refer it to a larger bench. So the matter has been referred to a larger bench. Now you can see the dates. It is in 2022, the two judges gave different opinion, and we are currently in October 2024, and today only I checked, the Supreme Court has yet not constituted the larger bench. So 2 years has happened, the Supreme Court has not constituted any larger bench now. So until unless Supreme Court has given any particular judgment, we are free to give our own opinion. Once the Supreme Court gives a judgment, we cannot give our opinion. Then we must follow the line. We must go by the judgment of the Supreme Court. Okay, now let's see the both side of the argument. What is the controversy all about? So first, let's see, like Bombay High Court and Madras High Court, sorry, Karnataka High Court has banned hijab. So what was the argument given by the court? Okay. First is that it is in the interest of larger academic interest. So it says that the state or the university which is banning hijab is doing it for the academic interest. How academic interest is being maintained? So they are saying that it will bring about uniformity in the class. So when there would be uniformity in the class, this is something which upholds the secular principle, or it will have the class which would be egalitarian, and in this process article 14, that is right to equality, is being enforced. Okay. Now one more thing is that the dress should not reveal the religion. So all the students in a classroom could be considered on the equal footing. That's for this purpose uniform is prescribed. Okay, so that a student will focus on gaining knowledge or education. Okay. Next is the court also gave the argument that donning of a hijab or niqab is not an essential religious practices. So since it's not an essential religious practice, it is not protected by Article 25 or freedom of religion. We shall come to this. What is this doctrine? This is also something that we shall discuss. Okay. So institution, and last argument is institution has right to maintain discipline on its premises. So the argument is simple. They are not saying that you cannot wear hijab or niqab. You can wear it, but you can wear it outside the premises of the school. Why? Because in a school, every student must be kept on equal footing. There is a need to bring about discipline. There is a need to bring about uniformity, and uniformity is in overall interest of the student, academic interest only. So that's why the Bombay High Court agreed with these arguments and said that school is right in banning the hijab. Okay. Yes, so yes, I am coming to that part. The next part is that the courts, like as we have said, that there are two instances. One instance is that a split verdict. That split verdict case, what happened? That one judge of the Supreme Court was not agreeing to this argument. And the second instance is that when Bombay High Court banned, the matter went to the Supreme Court. And the Supreme Court said, I mean, very good argument which has given, but then again, this is not the final judgment of Supreme Court. This is an interim judgment. An interim judgment is subject to change. Interim judgment means that till the time Supreme Court concludes the case, it gives an order, some respite is given. Okay. So court is saying that this is an invasion of privacy. So right to privacy means you have a right on yourself. You have a right to control the things that belong to you. And dress is definitely a part of my belongingness. So a student has a right to wear the things that he or she wants, and also he or she has a right to choice of dress. So when a school is saying that he or she must pull down or put off her hijab or niqab, in that case the institute or the institution is attacking the dignity. So in this case, what has happened, that when these students approached the school administration simply said that whatever you are wearing, but before entering the premises, you must put off your hijab, not niqab. Okay. So it is also considered by court as attack on dignity, and they have their freedom of choice. So the court said that it is violating Article 19(1)(a), like freedom of speech and expression. Freedom of speech and expression is also expressed through the kind of dress that you wear. It is also a violation of Article 20 1, and also court say that it is a violation of Article 25. Okay, and then this time when against the judgment of the Bombay High Court, the Supreme Court also said that why have you not banned something like tilak, bindi? These are also the symbols through which a person tells his or her identity. So you have selectively banned only a few items. You have not banned all the items which are representing the religious identity of a person. So why are you doing this selective targeting? And the court further said one more thing, that are you getting aware of this fact today that India is a multicultural society? India has always been a multi-religious society and various religious symbols have always been there. Why are you simply getting awakened on any particular day? So as of now, it seems that the Supreme Court is not in favor of these ban. Maybe the judgment will come 2 years down the line, 3 years down the line. Okay. But it seems prima facie that the court is not in favor of this ban. Okay. So I would suggest you that you also take the stand that the hijab or niqab should be allowed. And this point that everyone should look equal, this seems good on face of it, but in a multi-religious society, practically it never happens that all the students are looking equal and all that. Like especially if you consider like the Sikh student, they are allowed to wear their pagadi, etc., turban, and as the Supreme Court has pointed out, people wear tilak, chandan, etc. So practically India being a multi-religious society, it is not going to happen that people are not carrying any kind of symbols to the school. So we must be tolerant, and this does not impact the academics. I mean, if India is a secular country, India is a country where multiple religions exist. So if students are made aware of the existence of other religions, this is not going to hamper their academic progress. Okay, so in my opinion, you should take a stand not in favor of ban of hijab or niqab. If you have any question, you may ask. We can devote a minute or two for discussing this matter further. Yogesh, is it all right? Yeah. However, the court has said that no religious activity should be permitted in the school premises. It's not that you are wearing whatever dress you are wearing, and then in the school premises you are going and you are getting engaged in the religious activity. The court has said that a school is not a place for those things. So no religious activity in a school. However, it said that the dress is a matter of choice. The dress is a matter of freedom of speech and expression. So dress cannot be banned by the school administration. Last slide once. Next is doctrine of essential. Is this what it affect the right of minority to open it? One more problem with there. I mean, one argument that also you can write that this is also a fact. An NGO has conducted the study, and in which it has found that around 800 students have dropped out due to hijab ban. This is also a reality, na, that the society wants hijab to be uh, poor. So if the society wants it, there is definitely going to be various families who are not going to allow their girls to study if hijab is banned. They will feel it as an attack on their dignity. So in the interest of girls' education or women education also, hijab should not be banned. We should make all efforts possible to bring girls to the school. We should not create any obstacle in the path of the girls. Okay. No, open educational institution is a different thing. Minority institutions are allowed uh, to have a dress of their own and all those things. Okay. So minority educations can have all the right to regulate their things. They can also teach their cultural aspect, their religious aspect. Okay. So definitely this verdict is no way infringing on the rights of the minority education. Now we shall look to one aspect, one argument which was given in the last slide. We have seen the Bombay High Court as well as Karnataka High Court said that hijab is not a part of essential religious practices. So there we should discuss about this doctrine of essential religious practices. What is this? So as the name suggests, it's a doctrine. It's a doctrine means it is used to decipher by the court to decipher the essential religious practices. Okay, let's see what does it say. So it was invented by a 7-judge bench of Supreme Court in Roor Mutt case. Okay, in this case, the court says that if it forms the core of the religion, without which the religion would not be the same, this would be called essential religious practices. Okay, so any practice which is core of the religion, without which the religion would not be the same. For example, Hinduism involves idol worship. So idol worship is at the core of Hinduism. If a state is doing anything that restricts our right to do the idol worship, we can say that our freedom of religion is obstructed. Okay. And this doctrine says that only the essential religious practices are protected by right to freedom of religion. And this doctrine says that the court would decide that which of these practices are essential and integral to the religion. Okay. And the basics of this doctrine is from the speech given by B.R. Ambedkar in the Constitution. So B.R. Ambedkar has said the freedom of religion that we are giving is not unlimited freedom. This is restricted to the essential religious practices without which the religion would not remain the same. Okay, then who will decide that which are the religious practices which are essential? The Supreme Court said that courts would decide on case by case basis that which of the practices are essential or not. So from this we can say that there is definitely discretion with the judiciary. Okay, so when this came that whether the temple would be worshipped by only like only men, not women. So whether this is a core religious practice or not is to be decided in the court of law. Who will decide it? The judges will decide it. Okay, this is the doctrine of essential religious practices. It's very simple as the name suggests. So is the doctrine. Only thing that we have to remember is when it was invented. It was invented in Roor Mutt case 1954 and it is based on the speech given by B.R. Ambedkar in the Constitution. The important point is not that what this doctrine is, important point is the criticism of this doctrine. The problem with this doctrine is the first and foremost is the judges are going to decide what is essential religious practices. I mean, it's saying thing like that. What I mean, I have my family, and what is to be eaten by my family members, how they are going to behave, whether my son is going to say me papa or dad or father or any other thing, is to be decided by my neighbor. How is it logical? So the judges are an expert in law. They are not expert in theology. They are not expert in religious practices. So how can they decide what is core to my religion, what is not core to my religion? It should be ideally the religious leader of a particular community should be deciding what is core to their religion and what is not core to their religion. That's the biggest problem with this doctrine. Okay, first is there is no scientific or unique methodology. It involves subjectivity, and then it is also involving judicial overreach. Judges lack the religious expertise. Then it is against the religious norms and values. Sometimes, like to decide which is core and which is not core religious practices is itself against the social morality, because the society says that everything, all the religious practices that we are doing is important. The religion does not say that this is my core practice and this is not my core practice. Okay. Then last and most important thing is that this is, in a way, it allows a state interference in religious practices, and this is in violation or against the spirit of religious freedom. Exactly, judges to judges, very correct. I mean, as we have just seen in case of hijab controversy only, there were two judges who were not agreeing to it. They had the different opinion. So it will vary from judges to decide. I mean, this is, in a way, there is a subjectivity involved. From judges to judges, it will vary what is the religious core practice or not. I mean, just simply, just to, for the sake of the argument, if the religious functionaries, they were asked to say that which of the Newton's law or Einstein's law is right or wrong, wouldn't it be a travesty of science? साइंस का मजाक हो जाएगा कि नहीं? Now the religious priests are deciding whether Newton was right or Einstein was right. So similarly, if Newton or Einstein is sitting and deciding what is core of their religion, this is also a travesty of justice, travesty of religion. Neither of the two is expert of the other's field. Okay. So that's all. It's already 4 o'clock. Our time limits here. We have to conclude our session by the 4 o'clock. So we shall again see you in the tomorrow's class. In tomorrow's class, we are going to cover first constitutional morality. Then we are going to cover uniform civil code. And then we shall also discuss two questions rather. One question about right to privacy and another questions which was about Indian secularism and US secularism. Okay, because we have already discussed the Western secularism, Indian secularism. So these two questions also we are going to discuss in the tomorrow's class. If you want, you may write down the answer of these two questions which were asked in 2024 mains. So we are discussing the question from 2024 mains. You may write down these questions, and tomorrow when I discuss these questions, you can see what is right and what is wrong in your answers. Okay. Class की notification, it is almost fixed. The class timing is fixed from 2 p.m. to 4 p.m. You should come to our YouTube channel. There it will show in the live section, upcoming session. Okay, or else you can follow the Telegram channel of Narayana IAS Academy. There also the link would be posted. The link would be posted around 2 p.m. only. Okay, but it is certain the classes will happen, so you should wait for a few minutes. Come to our channel at 2 p.m. sharp. Okay, PDF would be on my Telegram channel, which is with the name of Madhusudan_IIT @Madhusudan_IIT. That is the name of my Telegram channel. There you will get the PDF, and that's all. See you tomorrow. If you have any doubt or whatever be your feedback, whether you have liked this session, not liked this session, whatever thing that you have liked, please post in the comment section. It would be very helpful in maintaining my motivation as well. And do bring your friends, spread the word that this session is going to cover, we are going to cover complete polity, and after, if this polity is successful, I would also request other teachers to come and cover all the subjects which are there in UPSC main syllabus. So complete mains syllabus will be covered if we get good turnout from the students. Okay, so do spread the word, bring your friends, and get ready for all the mains related content. See you again tomorrow. तब तक के लिए goodbye.